Okay, so we have 15 clauses and several amendments on file, a schedule and a title. Lead Speaker, Member Hyson, where would you like to start? So, first of all then, I will move, or I'll have you move that clauses 1 to 3 stand as printed.
You
Oh,
move it.
I move. Oh, the government. Okay, fair enough. Let's play it by the rules then. The government has moved that clauses 1 to 3 stand as printed. Do I have a seconder? And I'll put that. All those in favour say aye. Against, declare it carried. Clause 4, there is an amendment on file.
The amendment standing in my name.
It's been moved. Is it seconded?
Doesn't need to be seconded.
Doesn't need to be seconded? Jesus, it's been a while. In that case, would you like to speak, sir?
Well, perhaps given that we didn't hear about that in the second reading, and it's been filed only in the last day or so, in other words, hasn't otherwise been aired, the government hasn't had the opportunity to air it more prior to that. I just wonder whether there's anything that the Minister might have to inform the committee and the public record about what it's doing and the necessity for it.
Thank you, sir. I thank the member for his question, the ability to explain and put on the record the government's amendment in respect to clause 4. This is a technical amendment which substitutes the wording of clause 4 of the bill, which deals with the interaction between this legislation and the Commonwealth Fair Work Act 2009. The amended wording more accurately reflects the legal and constitutional division of industrial relations powers between the state and the Commonwealth. The amended wording is intended to have the same substantive effect as the original wording, while avoiding the risk of an interpretation that is inconsistent with that division of powers. I can further advise the member that I am advised that this does not seek or will not amend the status quo. It's an updating of a technical legal wording.
I might just ask for a little bit more in terms of the time and nature of the perceived necessity to make the change. And so, for the record, the bill provides for a carve-out by reference to Section 10, which is, say, its jurisdiction in relation to contracts of employment. And while I appreciate the government's indicated that this drafting by reference to excluded subject matter it probably does that more comprehensive. Well, probably does it comprehensively and more elegantly. I just ask the Minister the rationale, if any, specifically for the reference to Section 10 in the first place, and when and how the perception of the need to make the amendment might have arisen.
Thank you, sir. I can advise the member that Section 10 was, being the common law employment contract, is included, and the updated amendment that I've moved in my name still intends to include that. On the second part of the member's question around when or how this arose, I'm advised that this was a matter that arose in between the houses on a technical internal matter that was raised with the attorney on advice, and we've sought to correct that through this process now.
Then I'll put the amendment that stands in the Minister's name. Is that second? Oh, I don't need a seconder. All those in favour say aye. Against, declare it carried. Unless there are any more questions on clause 4. None on clause 4. They'll put clause 4 stand as printed. All those in favour say aye. Stand as amended, I beg your pardon. Yes, yes. Thank you, Clerk. Clause 4 as amended be agreed to. I'll put the question. All those in favour say aye. Against, declare it carried. Member Hyson, where would you like to go? Okay, so I'll put clause 5 to 12 stand as printed. All those in favour say aye. Against, declare it carried. Clause 13, there are amendments on file. Member for Hyson, would you like to speak to your amendments?
Yes, and I say, and thanks, Chair, reference to my amendments. There's two of them, so it might be convenient for the committee to deal with them together, otherwise I'd separate them out. They're both in relation to clause 13, and the first, as I foreshadowed in my second reading contribution, stipulating that in relation to the civil penalty that's the subject of section 104(1), then the penalty is providing for the penalty paid to the affected employee, and otherwise as per the clause, and the rationale that I've articulated is including drawing analogy to ordinary civil proceedings, and you know, unions are going to represent their members, core business, and from my point of view, I might just say that in doing so, there might be reasonable arguments for cost orders to be made in the usual way for that work. But we're here talking about a penalty provision that is a penalty that's made in circumstances where an employee or employees are wronged, and so the amendment will achieve the outcome that that money is paid to those affected employees. In relation to the second amendment, this is a straightforward matter of public accountability. In circumstances where the penalty amount is relatively modest and public accountability for public employers, local government, is going to play, I'd put it, as significant a role as the monetary amount. I mean, we can see analogies elsewhere where there is a relatively nominal monetary amount that's being paid, not I might say an amount that's that would be insignificant to an individual employee or group of employees, but in relation to a public sector employer or local government, relatively modest amount. And the best answer that the government's given so far, and I hope the government might be persuaded of the merits of this second aspect of the second amendment for these reasons. The effect of public reporting on acting as a deterrent for this bad conduct may speak more loudly and effectively than even the pecuniary penalty. And the best answer that's been given by the government so far is, well, say it conducts its proceedings in public, and sometimes, not always, sometimes it's publishing its reasons and judgment and so on, so you're there for full scrutiny. And so the scrutiny that is available that way is certainly a means by which there is public accountability. The amendment is providing for that to be reported so that it is on the record and before the Parliament. That has all been the subject of debate in another place, and none of which takes the government by surprise. But I invite the government to consider the amendments and indeed to support them, and for the Minister to enlighten the committee to the extent that the government might retain any particular reservation in relation to their merits.
Minister.
Thank you, sir. I thank the member for his contribution. The government opposes these two amendments moved by the opposition, and not persuaded by the matters put before the House by the Deputy Leader of the Opposition. If I can perhaps go through them separately. The first of which is the member's amendment which seeks to remove the court's discretion in respect to the awarding of the civil penalty. It is the government's position that it is both right and proper to ensure that the court exercises and may exercise that discretion in respect to a contravention of section 104(1). And the bill does not, as drafted, require the court to order a penalty payable to any particular person or organisation. It leaves it to the discretion of the court, and we consider that appropriate, and the drafting remains as such. Also note, and I thank the member in his second reading speech for seeking to give the House some confidence and reassurance that this movement, this amendment wasn't sought to be taken as anti-union, and I can only take the member on his word, but I also note that a leopard doesn't change its spots, and the Liberal Party, by its definition, hates what unions do and hates the fact that hates what working people do by joining together and exercising their collective voices. So I'm reassured by the member's contribution, but I'm not persuaded. And also note that in the member for Unley's absence, that somebody must carry the vociferous anti-union torch of which the member for Unley usually would. So I thank the member for the Deputy Leader of the Opposition for filling the unenviable position and unenviable role of the member for Unley as being the rabid anti-union spear carrier of which the Liberal Party is known for. In respect to the second amendment moved by the Deputy Leader, bit going on, carry on. We also oppose this amendment. I note that in the members moving this amendment that he notes that these matters are publicly reported and diligently by the various jurisdictions, in this case the Industrial Court. I'd also note that by way of existing deterrents, or the deterrent factor of which these matters should appropriately be considered, there are a suite of matters of which this House can consider within the existing way that courts and the media report these matters, and I would note particularly the matter in which a suite and bevy of former Liberal members have had their criminal convictions reported publicly would act as a way to dissuade some future behaviour by either way of corruption or serious drug offences. So the government is persuaded that the current mechanisms and the current public reporting would act in the public interest, and also these additional penalties which the bill contains do act as a particular deterrent factor for this type of unscrupulous behaviour from employers.
Member for Hyson.
Just two or three admonishments for the Minister in response. First of all, I'd just remind the Minister it's unparliamentary and contrary to standing orders to reflect on the presence or not of any particular member in the chamber from time to time. In relation to the leopard and spots point that the Minister raised, I just remind the Minister of my remarks on the public record, and specifically in relation to unions. I've been moved to refer on at least one occasion that comes to mind of the towering contribution of Sir John Carrick in the history of the Liberal Party nationally, a hero of mine, who, including right up to and including his obituary, was at pains to highlight the central important role of trade unions in this country in a whole lot of ways, and I think where the distinction is appropriately drawn, I'd certainly take the Carrick distinction, and that is where unions become political players, then there is clearly room to highlight the inappropriateness of union conduct from time to time. But I'm pretty glad about where my spots are, and while I'm not for changing them, I think it's important to highlight that I'm certainly on the record speaking up for the proper role of unions in this state and in this country, and this is legislation with which unions are centrally concerned. Indeed, I've made the point that the government has chosen in this bill to legislate in relation to costs of actions before the SAYAT, and to make it clear that costs are only to be awarded in the most unusual of circumstances. And I'd just highlight again, in response to the Minister, that if it were actually a bill that was about promoting the role of unions as formal advocates for members, including in processes such as those the subject of this bill, then it might have done so by way of the provisions in relation to the awarding of costs, for example. So that's been aired, and I just flag that's something I'd be very open to contemplating. Should the government be serious in its endeavours to stand up for unions and their appropriate role. And there's the third one. I think I mentioned 2 or 3 admonishments. The third one is, I think, a rather gratuitous reference to partisan reference that the Minister's just made in relation to criminal convictions. I'd just caution the Minister in relation to pots calling kettles. The incidents of criminal convictions of members of Parliament in this place over the years are certainly not exclusive to any particular side, and I won't, now amp up, some sort of tit for tat in that regard. But cheap shots are not appropriate, nor is it accurate to deploy partisanship in relation to references to criminal convictions. In relation to the substantive relevant point about the SAYAT's public reporting of its proceedings, reasons for judgment and so on, fair point to be made that the recent decision in relation to the United Firefighters Union is the subject of published reasons. If those interested are looking to interrogate what's happened, that's true. That's available. A system of open justice applies to that extent. And I've heard the government's response to the proposal that there be a positive reporting obligation. Obviously, I might say, or to emphasise it, the positive reporting obligation, the bringing to Parliament's attention in a systematic way of these incidents, I just put it to this House, will serve that superadded purpose of making it very clear that a relatively notional penalty, a civil penalty amount, will do a certain amount of work, and a superadded requirement to be publicly accountable, and indeed in this place will do some other work. I hear the government, and for the purposes of the record and assistance to the committee, I just make those further contributions.
No comments there. Is that just okay? We're dealing with.
The question is amendments 1 and 2.
Yeah. Yep. The question before the chair is that amendments 1 and 2, in the name of Member Fyson, be agreed to. All those in favour say aye. Those against say no. I call it for the noes. The question before the chair is that clause 13, as printed, be agreed to. All those in favour say aye. Those against say no. I call it for the ayes. Which clause would you like to go to next? That's it. Okay. The question before the chair is that clauses 14 and 15 as printed be agreed to. All those in favour say aye. Those against say no. I call it for the ayes. The question before the chair is that the schedule as printed be agreed to. All those in favour say aye. Those against say no. I call it for the ayes. Question before the chair is that the long title as printed be agreed to. All those in favour say aye. Those against say no. I call it for the ayes.